Okay, go ahead.
Thank you. Good evening, everybody. Welcome to the April 23rd Citizens Police Review Board meeting. As of this moment, we do not have quorum, so we will just be a meeting of informational. If one of the members that we're expecting does come, I will inform everybody. All right, so calling this meeting to order at 6:08. Sorry for the delay. We do have one excused member this evening, and right now we have one absent member in Ms. Shields. So about a week ago, did everybody get their minutes from our last meeting?
Yes.
All right. Do I have a motion to accept?
Dr. Gershio, you can't take any action.
Oh, that's right. I'm sorry. I'm ready to roll and we can't. Thank you. Thank you.
I would also note that there were two excused members, Mr. Kotler and Mr. Robinson, not one.
Oh, you're absolutely right. Thank you for the clarification.
Sure.
So again, if Ms. Shields signs on, we'll come back to the minutes. So the outline of tonight is a board business followed by case review, again, only informational. And if there is anybody here that would like to make a comment at the end of the meeting, 3-minute limit. My report this evening is that probably last evening, if you recall from last board meeting, we talked about our website, and the board agreed that we would do a survey of staff, board members, to hear their input about the webpage. So I think you received it probably around midnight last night. So if you could check your email, if you had a chance to do so, if you could take a few minutes before the deadline and send your responses in, that would be greatly appreciated. Staff, along with board members, if you could please do so. Important, our website is important, so we do want to hear your input. Thank you. Beth, report, informational report.
Thank you, Dr. Gershio, and good evening, everyone. And as you noted, no official business is being conducted at this time due to the absence of a quorum. And if that should change, then we can take care of some of the matters that members have to vote on. Otherwise, what I have to tell you tonight is strictly for informational purposes, and any guidance that you might want to offer me, I am happy to accept. The statement of financial interest has been distributed to everyone, and it is due to be filed by May 1st. That is a state ethics rule, and it was adopted by the city of Pittsburgh. And that statement of financial interest is intended to demonstrate to the public that members who have a vote and can influence policy or make decisions that will affect others are above board, and they do not but have a conflict of interest, so that they're pure in their work as they have been sworn to do. The copy of that statement is to be filed locally, meaning the board office, as well as with the city clerk. We had, over the last several weeks, Dr. Gershio mentioned to me that members were interested in the process when there is a vacancy in the staff at the board. Whether it's a sudden vacancy or a planned vacancy, that process is essentially the same. You have the authority under the charter and under the city code to hire your own staff. And for all intents and purposes, that direct responsibility for board members is that of the position of executive director. The other positions administratively are handled by the executive director. But what happens is the notification is made to the Department of Human Resources and Civil Service Commission. They then assure or review with the board the requirements and the qualifications for an individual who may be considered eligible for hiring into whatever position vacated. The advertising of the position, there are a lot of legal requirements around that, but this is where the city comes in to support your work. And Human Resources and Civil Service Commission handles all of the advertising. They then receive applications. They review those applications to assure that the individuals are qualified. Those who are then forwarded to the board or to the executive director, depending on the level of staff being hired. And at that point, the board or staff responsible conduct interviews, make selections, return nominees to Human Resources and Civil Service. And at that point, a background is conducted, a background investigation, and assurances that the individual does meet the qualifications and is presenting themselves honestly, that their qualifications are real and true. And at that point, the return to the board is, this person is fully qualified. Here's the background results. The board then, or the delegated staff person, makes the decision and an appointment is made to the vacant position. So that applies to every position in the city. Human Resources and Civil Service provide the technical side of that to assure that everybody is following the rules and that all legal obligations are fulfilled when it comes to employment. And keep in mind, that would also include any certification or validation of any accommodation or whatever it may be that a qualified applicant may be requesting. Any questions on that process?
That's what we reviewed.
The website review.
Yeah, that was pretty much what we talked about. I wanted to confirm it so that it was clear to everybody.
It's pretty much pro forma. It is what applies across the board to all employment in the city of Pittsburgh. You have the you and the Commission on Human Relations. Those two bodies have the independent authority to hire their director. But it has to go through the same procedural process. It's just that the decision makers are the independently appointed boards, not a city director. Okay, Dr. Gershio did mention the survey for the website. Now, last month, I did indicate that we would be sending a survey around. I didn't expect it to be the day before your next meeting, but that's what happened. That's why you received it last night. And as a result, we are asking that you do it. You fill out the survey and respond by May 1st. That's a week away. It shouldn't take more than 2 minutes, 3 minutes to complete the survey. It's real basic. But it'll give us an opportunity to put together the recommendations that from you, what you all would like to see on that site, and also the findings of our staff when staff reviewed the website last month. So we'd appreciate that coming back to us, and then we don't want to open up that website more than once for any kind of a rehab or a renovation on the website, because it's a lot of work. There's 25 years worth of information up there, and we can't piecemeal it. We're going to do it one time. So that's why we would like to gather everybody's suggestions now, and then we'll go forward with one effort to do whatever it is that we all deem appropriate to do to the website. Any questions on that? Okay. Mr. Ward and I met with the city solicitor on April 11th, I believe it was. And I had mentioned before that we were having some issues obtaining documents that previously we were able to obtain routinely. Little question about some other things that we weren't receiving that, again, in a timely fashion. And the big question of body-worn camera video, and just a complete change in the protocol. So we wanted to establish a protocol that could be, could withstand the test of time. You are entitled to certain information and materials in the charter and in the city code. The city is directed under the charter to cooperate fully, participate, and provide what you need to do your work. And they're not doing that. But, we've also experienced this when administrations have changed. We're 3 years into this. It's gotten more difficult to obtain what we need, but that also could be the Bureau of Police is in the midst of a huge reorganization. So we thought it best if we just go talk to the city solicitor, and that's what we did. It was a productive meeting. We have since gathered copies of document requests that have not been fulfilled, subpoenas that we delivered with the full knowledge that we would be holding on enforcing them because we understood there were other issues attached to our request, such as a subpoena for body-worn camera. There is an agreement. The city has delegated authority for granting access to body-worn camera video to the district attorney's office, which is permissible under the state statute. However, the district attorney's control is to be limited for video that may contain criminal acts, that may be evidence, that may be necessary for a prosecution or a criminal investigation, not for administrative misconduct, which is what we want to see. We are fully aware of what CREA protects. We know those boundaries. We don't cross them very often. We might try, but we don't. We know. Professionally, we understand what those limits are. And we're not seeking body-worn camera video that reflects a criminal investigation evidence that then could be a problem. So we talked to the solicitor about that. And Mr. Ward, if you want to supplement, I think we left it that we will provide a copy of those document requests that have been unfulfilled, a copy of the subpoenas, and determine how to pursue further discussion about the body-worn camera video. We also asked that the solicitor identify an assistant solicitor who would be pretty much our contact in the city solicitor's office and pretty much be our liaison, so that we don't fall into just the catch-all bin and, oh, here's another CPRB thing, somebody take care of it. We'd like to have one identified point. And I apologize for my friend here. Noel, is there anything I missed?
Your last sentence captured my remarks, which was to be that the city solicitor will inform us of a person on her staff who will be identified as the contact person, so it's not lost in the shuffle or not assigned. After the copies of subpoenas or document requests have been compiled and sent to the city solicitor, she'll review them with OMI to see what the problem is. Because frankly, what we're looking for is a protocol that works, something that can be reinstituted formally, where it had been done informally for years. We've had parameters that have been observed, and there's been some slippage, some of which required us to go to court, and we won. There have been other times when change of administration resulted in sort of a learning curve that needed to be climbed by the new folks to see how things were done. The good news here is that we got the personal attention with the city solicitor. She met with us alone, and she pledged to continue working with the board, with OMI, to see if we can establish a protocol that gets beyond April of 2024 and something that we can rely on for the foreseeable future. Having said that, she did carve out the issue with respect to body-worn cameras, which I think generated this inquiry in the first place, to the extent that she is, I think, proceeding cautiously with respect to body-worn camera footage, which she has deferred needs to be coordinated or presented initially to the district attorney. So it's an interesting concept that the city police or city solicitor are deferring to the county district attorney. But leaving that aside, that's presently the memorandum of understanding that exists, and those are the parameters within which we have to operate. So I figured we'd go for the low-hanging fruit first, which is the outstanding subpoenas and outstanding document requests, establish a protocol, and either simultaneously or soon after that protocol is established, to meet privately or openly with the district attorney to see what, if anything, can be done with respect to body-worn camera footage that is non-criminal, but rather pertains to administrative misconduct. Any comments or questions?
Specifically, and that's specifically carved out in the first item of that memorandum too, Mr.
Yes.
Ward. We noted that too, that there is a distinction made within the agreement. So
We
that
did.
just needs, yeah.
We did, but I would be remiss in not accentuating the fact that, notwithstanding that provision, that the solicitor is cautious with respect to production of documents or body-worn camera footage, I should say, that might implicate some concerns by the county district attorney. So it's a process. I think they are appreciative of us coming in again. Certainly wasn't hat in hand. It was firm. It was pleasant. It was cordial, but it was clear. We need this stuff. This is our information. What are you doing? Give it to us. So it was no mistake that our message was conveyed on your behalf.
And one of the other major parts of this that has been affected by a change in protocol at the Office of Municipal Investigations is they close cases based on body-worn camera video observation. And we don't have that benefit. We used to, we don't anymore. But in our investigations, we would have the ability to subpoena officer statements that are given under a protected warning, the Garrity warning. And OMI doesn't take many of them anymore because they're able to dispose of the complaints with the body-worn camera video. So that's a huge chunk of information that we no longer have access to because it no longer exists. So we have to get this resolved because we do, as Bill said, we need that stuff. Investigators need it. Any questions on that?
Ms. Pittenger, your mic's on mute.
Yeah, Beth, I do have
Yeah.
one point of clarity. They did say that they would release some of the information we've been waiting for, correct? Did we receive any of it, or this just happened and we didn't get it yet?
We have not received. We're still receiving what we have been receiving, which really instigated the urgency to have that meeting. And there's some question, excuse me. There's some question about the OMI may have been recently limited in what they're able to obtain from other sources as well. We're not certain about that. It could be related to a transition on the computer-aided dispatch system that's undergoing at the county level. You may recall years ago when we had a discussion about B3 and the change to an electronic run sheet and software that would integrate with county 911 so that all this information would flow automatically into the run sheets and the daily reports that the police filed. That never happened. But our understanding is that there's a new effort underway to upgrade the county system, which will have some of those elements that will be helpful for local automated record keeping, but that's not been completed yet. Now, it could be that OMI is not receiving some of that material because of the transition. I'm not saying they're deliberately withholding anything. But so there are a lot of variables to this whole thing. I don't want to mislead you. Okay. Any other questions about that whole process?
For a point of clarity, Ms. Pittenger, so we have subpoena powers for statements and records, reports and such. And so if I missed it, I apologize, but so body worn cameras does not fit in our subpoena power.
Mr. Ward may be better qualified to answer that, but my impression is that there's also another process available under the state statute, and that is to go to the Court of Common Pleas and request access to certain video obtained from body-worn police cameras. The specificity with which that request is to be made makes it so onerous that no citizen is going to go seeking body-worn camera video. You have to know everybody that would be potentially in the video, the precise time and location. It's a weird, difficult process to follow, but it is available. You can file with Court of Common Pleas. That costs money. And you can seek an order from them to direct. I guess now the question would be either the Bureau of Police or the district attorney, because the city's practice seems to be that all body-worn camera video is now in the custody of the district attorney's office. But it's our video. It's the city of Pittsburgh's property. So there's I don't know who the court would order to release that video or if they would. But within the agreement, the district attorney is delegated the authority to appear on behalf of the city and in any action seeking to divulge body-worn camera video. So it's confusing, Mr. Williams, to the extent that I think the legislature did the best they could to make body-worn camera video as obscure as possible to the common people. So that's why we would prefer to be able to make a protocol that can withstand that process before we go into court for the purpose of enforcing a subpoena for body-worn camera video.
Just picking up on that last point, I think the approach that we're recommending or discussing, I should say, is the better approach at this time. I don't like to lose, so I would be hesitant to go into court with a subpoena and then have to deal with a motion to quash the subpoena filed by the district attorney saying they're not entitled to this body-worn camera film because it pertains to a protected investigation under the Criminal History Record Information Act. And even though the judicial ruling might be very narrow, saying, yeah, in this case, I think the district attorney is correct. This video footage pertains to John Smith's prosecution. We're going to quash the subpoena. Well, that is a way of lingering for decades that the board tried to get something and then lost. We have been strategic in our, and I'm saying this on, on YouTube, but it's no secret. We have been strategically wise in terms of picking our battles and have been uniformly favorable to us when we have gone into court. So I think the better approach, the more, I suppose, professional approach, dealing with different agencies and different forms of government, is to try the collegial protocol through meetings first initially with the city solicitor and secondly with the district attorney, as opposed to, look, we just filed this subpoena to get the camera, and then say, oh yeah, well, they just filed a motion to quash. And guess what? You lost. Maybe we'd win, but let's make sure that our ducks are lined up before we go down that path.
And so my question to that is, it has been customary for us, I mean, it's protocol in any criminal proceeding that we pause all investigations until that has fully developed or been fully executed and they have gone through the criminal route, then we pick up on the administrative. So I'm just confused about the protection of the information given to the district attorney, because they're only pursuing on a criminal matter. And if those things, unless there is an extended process for which they're waiting, an investigatory process to say that, you know, there are reasons why they want to curtail release of this information, release of this data. But when they have made the decision, then the administrative process then now is permissible for us to be able to pick up. So I don't know what a hiccup is or the bump in the road. And I'm trying to get clarity. Like, if they're not going to move forward criminally, why would that not, given who we are and empowered to be who we are, why can't we have access to the information for any administrative purposes that we would be able to come in and speak to?
Can I pick up on that before you speak, Mr. Ward?
Sure.
You know, the other side to that is to Mr. Sheldon's point, this body is supposed to review any and all interactions. If it does become a case where the DA is taking up a case in a particular matter, that should not preclude Ms. Pittenger and her staff to at least have the information for a later date for when that is resolved, to then look at the administrative potential violations.
Well, the last part has not been the practice of this board. The last part is that the board has deferred while criminal investigations are pending. Mr. Williams raised a slightly different point, sort of at the end of the spectrum that Mr. Davis raised. As I understand Mr. Williams' comment, you know, why couldn't we get even protected information once a criminal investigation is closed? Well, for starters, sometimes we don't know if it's closed. You know, we don't know until the statute of limitations expires in some cases. And even then, at that point, the case is 5 years old. So it's kind of thorny. There's a comparable remedy in the federal courts with the Freedom of Information Act, and they have been successful in saying you're not getting this under FOIA, Freedom of Information Act, even though the investigation is closed, because it contains confidential, secret information that pertains to the investigation of the crime. So I realize that FOIA is different than the Privacy Act or the Right to Know Act in Pennsylvania. I can do another dive into that again, but from a procedural perspective, addressing Mr. Davis's point, this board has historically deferred investigation because of the very high risk of overlap. Because, you know, you bring a police officer in and he's going to say, I refuse to answer on the grounds that it may tend to incriminate me, which is his obvious Fifth Amendment right. But it also civilly or administratively presents an adverse inference that could be perceived as unfair to the officer because he has made that assertion on advice of counsel. So there are really two different issues here raised by both Mr. Williams and Mr. Davis. But I still think, notwithstanding that, the better approach is to try to hash it out informally with initially the city clerk and the district attorney thereafter.
To just add to that, that really we're looking at when does CREA protection end? And we can never find when that might be. The Criminal History Record Information Act seems to seal and protect anything that was involved in any kind of an investigation involving criminal question. So as a result, it doesn't seem, it's like it's perpetual. And the Right to Know Act in Pennsylvania, the Open Records Act, has a separate parallel track for police law enforcement records. It's not the same as the general public open records review and what's public and what's not. But that issue, and I've taken Mr. Ward a couple of times to task about, well, if the case has criminally been closed, then how can that material remain protected under CREA? And it still is. It's some kind of a seal that goes on it that you can't break. And I'm not sure we're in a position where we want to try to test that right now, as Mr. Ward counsels.
And I respect the position that Mr.
Davis,
Ward.
you indicated, I'm sorry, Sheldon, I'm sorry.
No, go ahead, please.
I was just going to say to Mr. Davis that, well, yes, the board has the obligation to review any incident from which a complaint arises. If it is criminal in nature, we have to step back until there is a clearance and disposition of any criminal allegation against a police officer who may have been involved in an incident for which a complaint has arisen. But by its very nature, we have no way of knowing what may or may not entail misconduct until we're sure that there's no implication of criminal conduct on the part of an officer involved in an incident. So when we open an executive director's complaint or inquiry of, we have to, I'm sorry, I'm here by myself and she is not a very happy dog right now. We have to assure that there's no question about a criminal activity on part of the officer, but we have to then make sure that if there is, that we stand back until such time as that has been formally disposed of. And then we can step in to consider administrative misconduct that may have been involved in the incident. But we have to rely on that which has been made public. We can't go digging in the criminal files. We have workarounds. We go to the clerk of court's office. We go through court records, but not everything is in that court record. So our staff have been very, very astute in finding workarounds to these obstacles, but there are still issues there that we have to abide. The rules tell us that we're not allowed to do anything if an officer is accused of any kind of criminal act until such time as it's been completely disposed of. And we have the state statutes that we have to contend with, in spite of being a charter city.
My other question was, how often is the process that you described to Mr. Williams used by this body? And you said there's a monetary cost, so I'm quite curious how much has been spent in that process in order for you to
No. If you're referring to the relationship with the district attorney for access to video, the last time that we approached them, it was a minimum of $600. And that was for the initial review. We wouldn't have to pay it until such time as we picked up the video. You can't, you have whole other issues there too. This is the public's property. You're one public agency paying another public agency to obtain public property. There's that whole philosophical issue. But fundamentally, we can't afford for 2 minutes of video to pay a few $100s every single time. And that's why the protocol, we want to build it in so that administrative misconduct review is not solely at the discretion of the district attorney. It's not appropriate. And it is not what was contemplated in their memorandum of understanding. It says so in the first item. So we have to sort that out and see how it can be established that which is administrative misconduct and not criminal maybe stays at home with the Pittsburgh police having jurisdiction over its release. I don't know. That's what we're trying to sort out. What we started out with the city solicitor meeting.
But the current process is that you're paying for it. I just want to be very clear about that.
No, we do not receive body-worn camera video.
I'm saying in the incidents that you do receive body-worn camera footage, do you pay for it?
We do not receive body-worn camera video.
At all. So I'm talking about, we've never received body-worn camera footage as a body?
That's not what I'm saying. No. We had a workaround with the Office of Municipal Investigations where our staff were permitted to observe video. That video was obtained by detail officers at OMI because civilians can't just go and get body-worn camera video. It was then taken over to the headquarters, that function of anybody seeing body-worn camera video. So our staff would go over to headquarters, and under the auspices of a now retired lieutenant at the delegation of the chief of police, our staff were permitted to view body-worn camera video. That stopped last year, I believe. It was with the transition of police leadership. Now, we have no access to observing body-worn camera video, which is why we're trying to get this process resolved.
Understood.
And we were never given
So
copies of body-worn camera video,
you
but
had
our staff were
sorry.
permitted to view it. And then when they weren't, or when there was a question, when it was stopped altogether and our staff could no longer go over to view the body-worn camera video, they would treat the presiding police officer as a witness to that video and ask questions of that officer, who would look at the video and then, we presume, answer honestly what they saw in that video. And so the staff would take that information as though it was a witness to the video. That was the best we could do. And that's what we did. Until now, we have no access to it unless we go to the district attorney. The last effort with the district attorney yielded the whole process, which is specificity of what you're looking for, the cost for retrieval, the cost for you to pick up a copy of the body-worn camera video.
So for me, right?
Even though we're looking just for administrative misconduct and not CREA protected information.
Excuse me,
for
Beth. I came late. I'm sorry. I apologize for being late. You said $600. What's $600?
$600 was the cost quoted to us by the district attorney's office to obtain a copy of a police encounter captured on police body-worn camera video.
Okay, thank you.
Welcome in tonight.
And I'm just as a statement for matter of record, even well until we go official. It appears as if we have moved from a collaborative process into more of an adversarial, and I'm troubled by this. With some of the changes that are happening, like it's in the best interest for the public and for the purposes of this board, even if the decision aligns. I mean, if there is no misconduct or if our decisions from our investigators shows some things that would either bring some sort of punitive or redress to the actions of the officer, or even if it's informational, it seems it's in the best interest of the public that we collectively be able to come through when complaints or have arisen, and I'm not sure what's happening that it has made a turn. I get it, that if they're trying to make it more, if they're giving us processes to go through, it just seems like the change that you have said with the change of leadership, and I'm troubled by saying, why aren't we doing this where across the country that we have seen where body-worn cameras have helped in a lot of processes, because now we have evidence that is just going beyond just statements made by complainants and officers. We now have evidentiary processes that now we can kind of vet this out. And I'm troubled that this has now become a bump in the road. And I don't know how to remedy it in this situation, but I'm making a statement as a representative of this board. It troubles me that this is why we exist, and that we try to bring answers to these so that we can properly vet these complaints and then bring some resolution that we at least are addressing the complaints of the public. And we're empowered to do on some part that I feel like we have a lot of teeth when it comes to subpoenaing to get statements and such, but on an administrative process, not a criminal, not an administrative process, it would seem like it would be beneficial that we would still work in parallel to try to bring resolution to the complaints that are risen. So I just want to make the statement.
And I just want to say, for myself, the public perception, right, before joining this body, is that the entire purpose of this body is to work hand in hand with the Bureau of Police in order to review such information. To hear that essentially this body and its staff is being treated as if we're just a general member of the public, and that even internally we don't have access to the information which is perceived that we should have, is a problematic to say. To just hear that there's a charge, essentially, $600 to a public agency, to another public agency over information that should be easily shared, regardless if it's a open case or not. I mean, that determination can be made relatively easy between both agencies. But again, but now just being closed off because now a Bureau of Police lieutenant, please correct me if I'm wrong, is no longer there, and now your access is cut off as far as observing. I just think that there needs to be a very holistic conversation, not only with the administration, but to Mr. Ward's point, the district attorney's office, since ultimately that's where the information lies at the moment.
Mr. Davis, just for the point of clarity,
Yeah.
this circumstance exists because of state statute. The Pennsylvania House of Representatives created a statute, Act 22 of 2017. The city of Pittsburgh's ability to accommodate what we want raises questions as to the lawfulness of them doing so, which is what we learned through the Criminal History Record Information Act limitations, and also the body-worn camera video. The law is clear about that. That's why we are trying to work out a protocol which has to address the bureaucratic hurdles related to managing a huge volume of body-worn camera video. The city shoved it over here to the district attorney and said, you take care of it. So now the DA is going to act on behalf of the city with regard to access to body-worn camera video, but will do so under the same strident requirements of the statute. We can't change the state statute here at the city level or even at the county level. So that's what we're trying to work with the city solicitor to determine, is there a workaround that will enable administrative misconduct issues to be segregated and remain under the control of the city through the Bureau of Police, rather than access only through a vetting conducted by the district attorney. I mean, it's a very frustrating bureaucratic situation, and it has to get worked out. We all know what the limitations are related to the state law that says what we can and cannot do. And so where do we find the little niche where we can satisfy our mandate, which is the whole reason we went there in the first place, to say this board has a mandate to do its work, and we cannot do our work because we're not getting the information and the evidence that we require to do our work. The board has not been lax, and the staff have been extraordinarily creative to obtain and find ways to get that information necessary so that you have a credible review that is based on evidence and not just speculation. But these obstacles are things that are beyond our local control to fix in a global way. We have to find that narrow place, and that's why we approach the city solicitor. The board, your integrity relies on you being able to do things above board. No side agreements, no deals, no, well, here, just let us know what you want and we'll give it to you. Because if it ever comes to a public hearing, or there's some other dispute that emerges from some action, then how do we honor any of it? You have to have a protocol that keeps everything above board and within the confines of what is statutorily permitted. And that's what we're trying to accomplish here with this engagement with the city solicitor. And there's been no effort ignored in getting this thing done. I mean, for 25 years, we've been dealing with this in one form or another. And we've always successfully come out with a process and a protocol that is satisfied at the moment for whatever administration or whatever particular investigation that we have, that we've been able to produce to the board something that is based on evidence and and lawfully obtained.
Progress, then once you maybe come to an agreement soon with the solicitor, we'll figure it out.
We absolutely will, and we will do it in a way that brings credit to you and your work and what you have always practiced with this board, all of your predecessors, having found a way to work that's honest work. There's nothing shady about it. You know, you've always been very straightforward and honest and worked with the people who have a common interest, a common goal, that the public's interest is at the heart of it all. And we've ended up with something that's worked. Unfortunately, what worked 10 years ago isn't working this year. So we'll find another way. And we'll continue to try another way to make sure that the continuity of your work isn't disrupted. There was discussion at the last meeting about the reorganization, the Bureau of Police, and the matrix report. Mr. Kotler had an extreme interest in that, so I will ask permission to defer that discussion until next month, when hopefully Mr. Kotler will be in attendance. And finally, when you have I see you have a quorum.
Yes, we do.
If you go into, I would ask, just as a matter of protocol, that perhaps when you open the case review section, that you might, at that point, any member who may want to recuse from the review of any particular case could do so at that point, so that if there's anything as we go along, that it's known at the beginning of the review before a review occurs and somebody recuses. That's just a protocol request. And that's it, unless you have other questions for me.
Hearing none, let's go back to the beginning of the agenda here, so that we now have quorum and our minutes can be reintroduced and discussed and voted upon. So going back to that, everybody should have received the minutes about a week or 10 days ago from Beth. So we need a motion to approve the minutes from March 26th meeting. Do I have a motion?
I make the motion.
Thank you. Do I have a second?
Second.
Thank you. Discussion? Hearing none? All in favor? By aye?
Aye.
All right.
Opposed? The minutes have been passed. So we're now ready to go to the case review. And so we will do that now. And again, does anybody need to recuse themselves from any of these cases before I begin the process? Everybody had a chance to look at them and review them okay. So we have one hearing for a public hearing for full investigation, and that's case 029-24. Do I have a motion?
Just to clarify, Dr. Gershia, it's not for public hearing, it's a full investigation.
Oh, I'm sorry, full investigation.
No worries.
I can't read my own thing here. There's 0 public hearings and 1 for full investigation.
I'll make the motion.
Second?
I second the motion.
Thank you. All in favor?
Aye.
Opposed? The ayes have it. All right, so we have 3 for full for 30-day extension of the full investigation. Case number 027-24ED. Case number 016-24. and case number 014-24ED. Do I have a motion?
I have a motion.
Thank you. Do I have a second?
Second.
Thank you. Discussion?
I want to little discussion on the matter itself. The details here says more time to determine if the subject officer violated Pittsburgh Borough Police policy, and as we were talking about video, and with the video that we seen, my question to that is, if I could get some, or can the board get some more detail about the issues related to that for the extension. So we have, and not questioning the investigators' desire for more time. We have very obvious video of something, and not saying that the officer was wrong. So I just kind of want to know context for the extension, given that it'd be different if there was no video along with the complaint. And so I raised the question only because we do have some evidence of something occurring to be able to determine whether or not it was protocol or policy or not.
I believe the investigator is Ms. Hunt. Are you with us, Tiffany?
Yes, I am.
Okay. Okay. As I recall, this is related to establishing whether or not the officer and what the terms were of any officer discipline that may have been involved in this case.
Yes, in this case, Mr. Sambala got back to me after I put this case up for summary review. And so I was confirming that the officer was in fact disciplined. And we found that he was. So that'll be closing based on that.
Okay.
So next month we'll see a different, gotcha.
Yeah, that's helpful. Thank you.
You're welcome.
And that, Sheldon, that was the only one on those three?
Yes, Dr. Gershio.
Oh, sorry. Thank you. Thank you, Mr. Williams. Alrighty, the next is
You need a vote.
oh, I'm sorry. The discussion gets me all mixed up. All in favor?
Aye.
Opposed? The ayes have it. Next is we have one that is unfounded, and that's case number 025-24. Do I have a motion?
I'll make the motion.
Thank you. Second?
Second.
Thank you. Discussion? All in favor? Aye.
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 Mr. Davis, do we hear you?
It's an aye.
Okay, thank you.
Sorry.
No worries. The ayes have it. And then we have 0 unsustainable, and we have one other. And that's case number 102-22. Do I have a motion?
I'll make the motion.
Thank you.
I'll
Second?
second it.
Thank you.
As a point of order, to be clear, the motion is for the dismissal as lack of cooperation as opposed to other.
Good
Is
point.
that from the officer?
It's the complainant.
The complaint, if you see the comment
Sorry.
there,
Yep, I got it.
all right, no worries.
Thank you.
Time for a vote. All in, other questions? All in favor? Aye.
Aye.
Opposed? The ayes have it. That ends our case study review for the evening. Next on the agenda is comments. Do we have anybody, Steph, on the I'm looking to see if we have anybody in the chat. I don't see any.
No chat, no one's in the chat, but Chris and Mark are here, so I'm sure they're saying hi. Hi, guys.
Hi, Ozarks. Alrighty, since there is no public comment tonight, just a reminder that our next regular meeting is at 6 p.m. on Tuesday, May 28th, 2024, via Zoom. If there's no other information, do I have a motion to end or adjourn this meeting at 7:04 p.m.?
I make a motion.
Thank you. Second?
Second.
Thank you. All in favor?
Aye.
Ayes have it. Everybody have a great month, and we'll see everybody on Tuesday, May 28th at 6 p.m.